Swayam Prabha. Digital India. Educated India.
I am Dr. Surendra Mehra, Assistant Professor, Law Department, Banaras Hindu University, Varanasi. So, this is my 8th lecture on execution, Order 21, Section 36 to 74. This topic execution is really very interesting and important one also, but you cannot compare this topic with other topic what we have already discussed. In section 9 we have discussed suit of civil nature, section 11, section 10 res sub judice and res judicata we have discussed. We have discussed place of suing, we have discussed suit by minor, we have discussed suit by indigent person, we have discussed order 39 temporary injunction, we have discussed this is execution, and apart from this also we will discuss appeal, various provision of appeal in our next lecture, that is 9th one, and 10th review revision. So, this topic is very interesting, and why I am saying this is interesting? Because this is the execution. So far in my lecture you have even read about or understood about decree and order also. You have read number of times decree, you will get decree, there is a civil suit, and on the basis of the case, if you court decide, honorable civil court decide case on merit, then in civil matter court passes a decree. Sometimes in between court passes interlocutory or different orders also, depending on the application, depending on the instant need of the concerned parties. I told you apart from it, like how the trial, civil trial or civil proceedings takes place from beginning to end. If you attend all my previous session, then you can come to know these things, but I have already told you, but just for the sake of this convenience execution lecture, again this becomes important for me to tell you what proceedings takes place from beginning to end. Like on the first date of hearing, what happens after presentation of your plaint, how court examines the plaintiff, then issuance of summon under order 5, then written statement by the defendant, then framing of issues under order 14 of CPC, how court frames issues on the basis of the pleading after hearing both the parties and after going through pleading of the case, civil case, then how court invites evidence on the basis of the list of witnesses. Although both parties submit list of witnesses, then court invites one by one all witnesses, serve summons to witnesses and invite all summons whosoever the court think this is relevant witness, and examination and cross examination will take place, finally argument, then judgment, then decree. In between you can get order also. I have given examples of different orders also, like under order 6 rule 17, this is amendment of pleading, return of plaint, order 7 rule 10, apart from it also frame of suit. This execution basically is the enforcement of those decree and orders what you have got out of the case. I will clear the meaning of this one, and I will try to make it interesting also, like, and I will compare simultaneously with the criminal matters also, because normally what I have seen students take interest in criminal matters, so they can understand this one. But just before starting or before discussing beginning with this session, I will let you know this order 21 is the biggest order in RCPC, and this has 106 rules, 106 rules, and all rules are important. And I will suggest you, if you go through these although all rules are not important, but at least in the beginning you should read all these rules. 106 rules. Otherwise, in other orders you will find 15, 16, 17, 18 as per in order first parties to suit, you will find only maximum 16 or 17 rules. In second order, that is frame of suit, you will find hardly 11 or 12 rules. Then third, recognized agent, order recognized agent, third order, fourth, framing of institution of suit, fifth, summons, sixth, pleading, order 6, order 7, plaint, order 8, written statement, order 9, appearance and non appearance of parties. So, these kind of orders, around 51 orders we have, but this order is biggest one, because this order contains 106 rules, and in sections you can study from 36 to 74. Then this picture will be clear to you what is execution. Normally I suggest to my students, I am coming on this meaning, normally I suggest to students, instead of going in execution, the party after getting decree or order, party try to sort it out, or through mutual consent. For this, for understanding this execution, there are two important terms, that is decree holder, I will write it here, decree holder and judgment debtor. Decree holder means in whose favor the court has passed decree, who has won the case, against in whose favor the decree has been passed is called decree holder. It means who is holding the decree, who is holding the decree, in whose favor the decree has been passed. These two terms again number of times I will repeat, decree holder and judgment debtor. Second term is judgment debtor. Judgment debtor. Judgment debtor, against whom the decree has been passed, against whom the decree holder filed the application of execution, is called judgment debtor. Decree holder means in whose favor the decree has been passed, and judgment debtor means against whom the decree has been passed, who will provide the relief or who will give the relief of the decree. These two terms are very important, decree holder and judgment debtor. So, first year student must understand these two words. You have heard about plaintiff and defendant, plaintiff who files the suit, defendant against whom we file the suit. We have read this one also, who is plaintiff and who is defendant in civil matter. But in execution we use these two terms, decree holder and judgment debtor. So, now I am coming on this one, what is the meaning of execution? And before this discussing, even because this is expression and I will compare it, the term execution has not been defined in the code of civil procedure, but I will say word execution is the enforcement of the decree by the process of the court as to enable the decree holder to realize the fruits of the decree. Execution is basically basically enforcement of decrees and orders in order to get the fruits of the decree through judicial process. Court will adopt a judicial process, and section 51 there are different modes by which court can execute your decree, but basically this is the enforcement of decree. Decree you can take in that sense also, decree or order is just a piece of paper, whatever has been given by the court. Judgment, decree or order, judgment is just a statement. This is the difference between judgment, decree and order. Judgment is just a statement, decree is a formal expression, order is a formal expression. Before decree always, I mean normally court gives judgment also, depends on the court. This is only statement. Upon that statement what decree is drawn up by the court, that is called, what order is drawn up by the court, that is called decree. So, basically execution is the enforcement of decree. If there is no enforcement, then what is the benefit of what is the benefit for the decree holder? Can you satisfy only with the decree? Decree means a piece of paper, okay, judgment that has been passed in your favor. Try to understand in that sense. This is only a piece of paper, 10 page paper or 20 page paper, whatever the judgment or decree is there. But if you do not, suppose a compensation has been awarded to you 10 lakh rupees or 20 lakh rupees in your case, but if you have only decree in your hand and your judgment debtor is not giving you the benefit out, I mean outside the court also this can be given, your judgment debtor can give you outside the court, okay, because now you have won the case, so take this one, will not file application under order 21 of CPC, because this is separate application exactly. After getting decree and order, you have to try, the court will try your case from beginning to end, then you will get decree or order, any order. But after that order or after getting that decree, if you do not get the fruits of the decree, the benefits of the decree, then what is the relevance of this one? So that is the reason I am telling, in order 21 we file separate application after getting decree or order, we file separate application for execution. But if you sort it out, I mean sort it out mutually outside the court, there are two mode of, basically within the court also or through court also you can get it executed, or outside the court also the parties, decree holder and judgment debtor, can talk together, they can discuss the things, like now you are judgment debtor and I am decree holder, if judgment debtor is good one, a man, a law abiding man, if he is good one, a man of good nature, then he will say okay, it is okay, what is a, because otherwise again you will engage lawyer, if your previous lawyer is saying ki no, I will charge separate for this application order 21, because this is very lengthy procedure, execution is very lengthy procedure, complicated procedure, it is not so easy, like, because this is done by or through the executive authority, this is not done by the judicial authority. The moment you read all modes of execution, there are 5 modes of execution, then you can come to know like how this is difficult. The first mode is by specifically delivery of property, in case of specific relief act, specific delivery of movable property, specific delivery of immovable property. How court would deliver? Court is judicial court, court will pass order and then finally direct to the executive authority, go and execute this one. Then executive authority, you know the scene of executive authority, how, I mean what kind of, from one table to another table, from another table to another next table, this kind of thing will take place and you will run to the executive authority from this to this office. For getting actual possession, there is another ground, that is say attachment and sale, another mode of execution after specific delivery, attachment and sale, sometime attachment without sale, sometime with sale, depends on the nature of the property. If there is a, because in case of attachment, if court is providing you actual possession, there are two possession, actual possession and symbolic possession, and in execution we normally ask for actual possession of property, movable property or immovable property, when you get the actual possession of your property from the judgment debtor. For getting actual possession of property, sometime we need the appointment of district duty magistrate. Duty magistrate will go on the place of occurrence, like suppose for example, if there is a plot of land and you want the possession of your plot of land against the judgment debtor, because you are decree holder, if you need that plot of land and decree judgment debtor is not giving you easily, then you need the appointment of duty magistrate along with the help of police. Duty magistrate will go, and this is done by the executive authority, deputy commissioner will appoint any duty magistrate on the basis of your application, on the basis of that order along with the application and your order. That duty magistrate can be either Nayab Tehsildar or any other officer, executive officer of the court, executive officer of the government. He will go on the place of occurrence, on the place of dispute, then he will provide, and along with police, otherwise judgment debtor can be a mafia man, he can be a land mafia, or he can be a different kind of man. So this is very, what I am trying to tell you with this example, execution is very difficult one. This is not as what you have got decree, right? I mean till date you have got decree, court has awarded you, court has given you, passes a decree in your favor after trial of the case. whatever has been demanded by the court, you provided all those things, because court is judicial court, and this is I am talking about executive authority. First mode of execution is specific delivery of property, second is attachment and sale with or without sale, third one is arrest and detention, fourth one is appointment of receiver, and fifth one is any other mode. So, if you read these modes of execution along with rules of order 21, 106 rules you have, mind it, I will give you few rules relating to this one, 31, 35, 36 for specific delivery of specific movable property. We have rule 31 of order 21, do not get confused. Separate sections we have from 36 to 74, you can read that one also, but those sections are in brief from 36 to 74, and separately we have order 21 also of CPC, in which we have 106 rules. So, but before going through, before understanding all these rules and provision, you must understand the meaning of execution. I am telling you, if you sort out your matter after getting decree with the judgment debtor outside the court, then that is the best way. In criminal matter, you can compare this execution with the criminal matter. This is the equivalent process. Basically, execution compels the judgment debtor. If he is a good man, he will give you without outside the court, but if he is not a good man, then he will not give. Then you file application, decree holder file application under order 21 of CPC for execution. Kindly enforce my decree. I need the fruits of the decree, and court through judicial process will provide you the fruits of the decree. In criminal matter, we have bailable offence, non bailable offence, just for the sake of your convenience, understanding what is the difference between, or how this is equivalent to criminal procedure, this execution. Just for your understanding, to make you understand, I am giving the example of criminal law. In bailable matter or in non bailable matters, the moment police lodge FIR, in non bailable matters police arrest, and then finally police, I mean, provide the charge sheet, prepare the police report and charge sheet, and then framing of charge, and then trial will take place. Police will arrest. But here in civil matter, in bailable also, I mean bailable offence, the moment you FIR lodge in non bailable offence, you become, I mean, compelled one, like now the process has started, so you do all those things. But in execution, after getting decree and judgment, this is another separate application. Without this, this execution basically compels the party. In criminal matter, arrest compels the party, search and seizure compels the party. Only the FIR, the moment FIR get lodged, that compels the accused or the wrongdoer. But here execution compels the judgment debtor. He will not give you easily. So, that is the reason I am telling you this is very complicated procedure. But the meaning you get from this first slide, you will come to know this is the enforcement of the decree, mark from here, enforcement of the decree and order by the process of the court to enable the decree holder to realize the fruits of the decree. Without this, you cannot get fruits of the decree. I told you how in case of immovable property, for getting possession of immovable property, how you need the appointment of district magistrate, duty magistrate through from the executive authority, or otherwise also arrest and detention. See section 55 to 59, you will come to know what is the arrest and detention, what is the appointment of receiver, all those modes we will discuss here in this session. So, execution basically what you have to mean, after getting decree or judgment in your favor, then normally decree holder files application under order 21, separate application. Although this is a part of same suit, because till you get the possession of property, the matter has not been ended finally. But after getting decree or judgment order in your favor, you need to file separate application if your judgment debtor is not permitting you or giving the possession of the property or giving whatever the relief has been awarded or has been given in the decree or order. Then you need separate application, because you will be compelled one. Your decree holder is not giving you the things whatever has been awarded by the civil courts. So, this is enforcement, giving effect to decree. Execution is enforcement of decree through judicial process, which enables the decree holder to realize to get the fruits of the decree, and what is the fruits of the decree? Whatever relief has been given by you, the court, compensation, rate of interest, interest amount, suppose money decree, the amount of money whatever you have claimed. In case of movable and immovable property, the possession of the property, all those things depends on your case, whatever you are asking. Suit for recovery of money, then you need money, whatever has been taken by the defendant from you. So, all those reliefs I am telling you, this is enforcement of the decree. These are the points of execution. If you got the meaning of execution, these are the points of execution. Ki courts, first of all, these are the different heads of, subheads of, I will say, the execution, and you should read as per these heads this execution, the entire execution order, order 21 and section 36 to 74, all entire 106 rules of order 21. Separate it, first go through section 36 to 74, because those sections are in brief, you can come to know easily. Then order 21, because there are minute rules relating to execution. You will get answer of your all questions, no need to ask from anybody else. Sir, what will take place? Sometimes young lawyers ask from the senior lawyers also, sir, this is execution and really we have not read anything, or we do not know what application would be there. Just go through bare act, nothing else, everything is there in the bare act, CPC bare act, Civil Procedure Code bare act, in order 21. Otherwise also other orders are also good one. No doubt case law is there, so those case laws are supplementary one. But for this, because court will also see the bare act, if you file any application, okay, which order, which rule application you are filing, Mr. Advocate, all those things. So, your orders and sections are complete one. Go through bare act, seriously read your bare act, language, minutely language of your bare act, you will come to know about CPC. So, these are the differences. First, the court which may execute the decree, this is the first question before a decree holder, before whom the court he should file application, decree holder should file application. This is first. Second, application for execution, what would this contain? So, how stay of execution will take place? These are mode of execution, different mode of execution, what I have told you, 5 mode of execution: specific delivery or arrest and detention, attachment and sale, appointment of receiver and other things. Attachment of property, how this will take place? Sale of property, how? Because this takes place through auction by the order of the court. Sale of property, if the property has been attached by the court, then it does not mean that court will sell it out without any following any procedure. There is a proper auction, there is a need of proper order of the court, and the entire procedure is very transparent one. Procedure of sale, procedure of auction, the same procedure court will follow, the drum beating and inviting all applications and all those things, whosoever want to purchase the property, otherwise sale will not take place. And finally, court will conclude how much decree holder will take and how much the remaining portion of the purchase amount will go to the judgment debtor also. Transparent one, no confusion on this point, how this sale of property will take place. Attachment of property, whether property can be attached or not attached, this is section 60. Normally I tell you this section is very important, section 60, property which can be attached and which cannot be attached, very good one. I will tell you how 9 properties in this section 60 itself, there is a complete list, go through that list also, you will come to know. Some students say no, the property which cannot be attached is some different section. In section 60 itself, both the property which can be attached and which cannot be attached, which can be attached is of only 9 kinds of property, which cannot be attached is of 20 kinds of property, 20 kinds of property. I will let you know few things regarding this one property which can be attached. For that, although you have to read section, but I will let you know otherwise. Delivery of possession, how this will take place, and distribution of assets, how this will take. So, these are different heads, guys, you have to keep in your mind while studying execution under order 21 of CPC. Otherwise, you will not understand the complete procedure of execution. This is basically a procedure. Here you are not talking about something like when you were in trial before the civil court, then you were pleading, you were giving your direct evidence or indirect evidence, examination, chief examination, examination of concerned parties, plaintiff, defendant, all those things were taking place, framing of issues. But here just relief you have already got in the form of decree or in the form of order. Here you are just trying to get the benefit or fruits of your decree, fruits of your order, and that is why I am saying this is really very difficult, from getting money from the pocket of opposite party or from the pocket of decree holder, or even sometimes I say getting money from the pocket of your client, your fee I mean to say, whatever you charge for your services, that is really very difficult. So, this is about I am telling you, this is the fruits of the decree. Suppose court has awarded money in lakhs of rupees, then how would you get? Party will say, and party decree holder will, judgment debtor will not give you easily. Practically you have to understand this one. You should see the pocket size of your judgment debtor also. Normally I suggest to students, you should see before filing civil suit the pocket size of your opposite party against whom you are filing suit, whether he is in a position to pay the amount or not. If he is not in that position, then get it sorted out through lok adalat, whatever the amount or whatever, if there is a mutual understanding between the concerned party, then that is good one. But take your money, whatever the amount he is giving with the permission of the court, then this is good one. Arbitration and conciliation is good one. If you sort out your matter through arbitration and conciliation, if you sort out your matter through lok adalat, then that is also good one. At least you will save your money, you will save your time. But civil proceeding after getting decree and order and getting the fruits of the decree is really very difficult. I am emphasizing this one. I am telling you the importance of arbitration and conciliation. I am telling you the importance of lok adalat. So, these heads you have to keep it in mind before discussing these, understanding the execution complete. This is the definition of court, section 37, which passed a decree. I will come read it out. Section 37 enlarged the scope of expression, court which passes a decree with the object of giving greater facility to a decree holder to realize the fruits of the decree passed in his favor. The following courts within the special, I mean this is why you have to read the definition of court, because you will come to know who can or which court can execute your decree. The first court, the court of first instance which actually passed the decree, this court can execute your decree. Before this court you can file your application in order 21 of CPC. The court which actually passed the decree, the same court can execute the decree. Second one, the court of first instance in case of appellate decree. Suppose you are in appeal, then appellate court decide finally whether decree is final one or not. Then the first court of first instance will execute your decree, because the appellate court will not execute your decree. The first court will execute your decree. Third one, where the court of first instance has ceased to exist, which would have jurisdiction to try the suit at the time of the execution, then again the court of first instance, where the court of first instance has ceased to exist, the court which would have jurisdiction, then definitely you have understood this one. If the court is not there in existence, then whatever the court has jurisdiction at the moment, then that court will execute your decree, because this question is very relevant one. Before whom we should file application of order 21 of CPC? Execution application. Decree you have got, no doubt. Order you have got, no doubt, from the trial court, from the civil court. But after getting decree, after becoming decree holder, where the decree holder, to whom the decree holder will approach? Answer will get in section 37. The court of first instance which passed the decree, in appellate court the court of again first instance, and here where the court is no more in existence, then this court would. And fourth one, where the court of first has ceased to have jurisdiction to execute. Both these two provisions are different one. Read the language and you will come to know. Has ceased to have jurisdiction to execute the decree, the court which at the time of execution would have had judicial to try this suit at the time of execution. Jurisdiction and not in existence, both are two different. Suppose this court has jurisdiction today, tomorrow court can take it back, because there is a allotment of work among the judicial officers. So, accordingly honorable courts decide, okay, this court has this jurisdiction, this court has this jurisdiction, changing on month basis or sometimes depending on the time and depending on the work, it gets changes also. This court has jurisdiction, this court has jurisdiction. Jurisdiction, I told you, authority to decide, otherwise you cannot file your application of execution. So, within as per section 37 you have to file. So, this is the meaning of definition of court passed the decree, because normally we know this thing, the same court before, I mean the court which has awarded or which has given you passed a decree, the court will execute the decree also, but apart from this case there can be other cases also, the same thing you will get answer. Second, section 38, the court first mainly the court by which decree may be executed, which passed it, you note. Second is by the court to which it is sent for execution, which is to which it is sent for execution, very important. Rule section 46, not rule, section 46, precept order, precept order, this is precept order to which it is sent for execution. Why we sent it for execution before the another court? Suppose the court pass the decree has no jurisdiction, there are certain points you can club it with this rule 39 to 42 ki transfer of decree may be in two ways, shoe motor on the application of the decree holder, no doubt, but these are the basis rule, this one, first, second, third and fourth. When you apply to the court, your lordship, I mean kindly transfer my decree before this court, or shoe motor also court can take this decision, no problem with that. The first is judgment debtor actually and voluntarily resides or carries on business or personally works for gain within the local limits of the jurisdiction of such court. When you feel the moment you got decree or during the trial the jurisdiction, I mean your judgment debtor was there, but now because you need the fruits of the decree, so now you realize the judgment debtor is actually residing there, voluntary residing there, separate place. In order place of suing, I have already told you the meaning of this one. You can read for this one place of suing session and understand this one, what is the meaning of actual residence, what is the meaning of voluntary residence, what is the meaning of carrying on business, what is the meaning of personally works for gain, both separate. These four places of work can be there, work and residence can be there, because you need the decree. Suppose your judgment debtor has property over there because he is working personally working there in Allahabad and you are sitting in Varanasi, you are residing in Varanasi and Varanasi court has passed the decree. Example, you have to understand, you have got decree from the Varanasi court, but your judgment debtor now, because at the time of execution he is, although he is residing in Varanasi, but he is working, he has personal property in Allahabad district court, within the jurisdiction of Allahabad district court. Then who will execute the decree? Varanasi court can execute the decree if the property is situated with the Varanasi, if the property, sufficient property is there in the Varanasi. If the sufficient property of your judgment debtor is not there in Varanasi, or immovable property is also not situated there in Varanasi, who knows, because trial takes place, it is a dilatory process, sometime 5 year, 10 year. After within 10 year, what has happened, what was the earlier situation of judgment debtor and what is the present situation of judgment debtor, who knows this one. So, Varanasi court can execute your decree when Varanasi court has sufficient property within the jurisdiction, or judgment debtor has sufficient property within the jurisdiction, or property situated within the Varanasi court, within the Varanasi district jurisdiction. Then in that case you people, because you the judgment decree holder will realize the situation, decree holder has to assess this thing from where he can get it executed easily. This Varanasi court will get problem. So, that is the reason I am saying judge decree holder has to assess this one. That is the reason I was saying you have to see the pocket size, you have to see practically how to get money from the opposite party, it is not so easy. So, if you are assessing it properly, no, he has sufficient property over there and Allahabad court can execute it easily, then you will pray. The decree holder will pray to the Varanasi court, your lordship kindly transfer my decree, and then Varanasi court will issue a order of precept, we call it precept in rules section 46, and direct the or request the Allahabad court to execute the decree, and along with the decree the property, all those things, whatever detail has been provided by the decree holder to the court, that will be along with that decree. Okay, this is the specification of property, this is the value of property, this is the property what is there over there in Allahabad district jurisdiction. Then Allahabad district court will execute the decree, because you need the fruits of the decree, you need the benefits of the decree, you need the possession of the property, whatever relief you need. So, actually and voluntary resides, carrying on business and personally works for gain. Second, the judgment debtor does not have property sufficient to satisfy the decree within the local limits of the jurisdiction of the court. If you do not have, judgment debtor does not have sufficient property, then in that case also. Okay, now the property sufficient, he has sufficient property there in Kanpur or in Allahabad district court, then you can pray to the court which has passed the decree, kindly transfer my decree. The decree directs the sale or delivery of immovable property situated outside the local limits of the jurisdiction of such court. Outside the local limit, I have already covered this one. The court which passes the decree consider it necessary for any other reasons to be recorded in writing. So, these are the grounds of transfer of decree. Normally, no doubt this one, the court which passed the decree will execute it, but if it is, you find these 4 things are there, these 4 grounds are there, these 4 grounds are there, then you can pray for the transfer of the decree, that is called precept, and court will transfer it through the precept order, and that court will execute the decree. This is called transfer of decree. This is precept order. You can go through. Precept means command, order or writ or warrant, section 60. The decree holder, the court which passed the decree, may issue a precept to any other court which would be competent to execute, to other court, issue a precept to any other court which would be competent to execute such decree to attach any property belonging to the judgment debtor and specified in the precept. Court will mention in the precept order, okay, this is the property value and all those things. So, accordingly the court will execute the decree. Can decree be executed at more than one place? So, this is same the thing what I have covered, copy of decree, certification of non certification or part certification, copy of an order, all these things. Now, the power of executing court, section 42, what power can be exercised by the executing court? Power to send the decree for execution to another court, 39, precept order. 39 is clearly talking about how or when court will transfer the decree. Second, execute the decree against legal representative of the judgment debtor, section 50 for this one we have, because legal representative will be answerable only for that property what really comes in his hand. Legal representative, only then you can get it executed against the legal representative. What the judgment debtor has got from his father or parents, actually what he gets in his hand, he will be answerable only for that much. Judgment debtor means legal representative of judgment debtor, or if he has not disposed it properly. So, you should read section 50, up to what extent you will be responsible. You have read pious obligation and all those things, but CPC section 50 is saying something else. Up to what extent legal representative will be responsible, legal heirs will be responsible if there is a execution against him, execution process against him. Power to order attachment of a decree, these all these things. Another one, application for execution, we have a rule order 21, 10 to 25 and 5 to 106. All proceeding in execution commence with the filing of an application for execution. Who can file application? Decree holder, legal representative of the decree holder if decree holder is dead, any representative of the decree holder, any person claiming under decree holder, transferee of the decree holder, one or more of the joint decree holder, any person having special interest, these persons can file application for execution. Simple one. A person who is neither a decree holder or has a right to exist a decree this one also third party stranger, all these things, judgment debtor, legal representative, these all things are same, just you should go through and you will come to know. This is stay of execution, rule 26. This rule lays down, I am reading language, that the executing court shall on sufficient reason, sufficient cause being shown, and on the judgment debtor being furnishing security, judgment debtor furnishing security or fulfilling such condition as may be imposed on him, stay execution of a decree for a reasonable time to enable the judgment debtor to apply. Judgment debtor can also apply for stay of execution if he feels ki otherwise he will satisfy the decree, fruits of the decree, then he can apply, okay, kindly give me reasonable time, because this is practical one. If you do not have money, if suppose judgment debtor does not have money, then he cannot pay. So, he can take date also, he can take some extension, reasonable time extension, 15 days, 1 month as per the need, and understanding the court will also grant this reasonable time, because the purpose is not to send someone behind the civil imprisonment, the purpose is not to attach and sell the property of judgment debtor, the purpose is not appointment of receiver of for property or specific delivery of property. If you are otherwise, judgment debtor is otherwise satisfying the fruits of the decree, satisfying the decree, and decree holder is satisfied, then there is no problem, no need of this and following this entire procedure of execution. Question is of if he is giving, if he is really good one, then he will ask for some time, your lordship kindly give me 1 month time, I will pay this amount, no need to follow this entire procedure. So, court is also liberal one, no doubt court keep all these things, sensitive one, keep all these things in mind, okay, this is the real position of judgment debtor, right now he cannot give this time, he cannot give this much amount of money, he needs some time, so court will grant. So, this is called stay of execution. These are the modes of execution what I was telling you in beginning, these 5 modes, section 51 is specifically by delivery of any property specifically decreed, specific delivery of property, this property can be movable and immovable. Section rule 31 deals with specific delivery of movable property, and 35 and 36, rule 36 of order 21 deals with immovable property, how this delivery will take place, all those rules are there. 31 and 35 of 35 and 36 of your order 21, read this properly, delivery of any property specifically decreed, whether this is really possible or not, specific delivery, specific relief act you have 1963, you will come to know property which can be specifically decreed, section 10 and section 14 of specific relief act, property which cannot be specifically decreed, but still there is a procedure. This is just these modes are just for the compelling the opposite party, if otherwise you take judgment debtor is taking I mean getting stay, then there is no problem, if he is otherwise satisfying the property outside the court, satisfying the decree outside the court, then also there is no problem. If these two things are not there, neither he is satisfying outside the court nor is taking stay on execution, then these modes of execution will come in picture. I hope you are understanding this one, because you are compelling, the court will compel through these modes to the judgment debtor on the application of the decree holder, because decree holder needs the benefit of the decree, fruits of the decree, execution, enforcement of decree, enforcement of order specifically decreed. So, these rules you have to attachment, second attachment and sale or by sale without attachment, separate this one, attachment and sale. Attachment is the second provision, if the by specifically delivery is not possible, this first mode is not good one or is not of use, because I told you section 10 and section 14 of specific relief act specifically saying property which can be attached, which cannot be attached, and you are asking for some specific delivery of property which cannot be attached. I given you example in other session also, like can you compel late Sri Lata Mangeshkar, now not Lata Mangeshkar, but there are present singers, can you compel just to sing for you? You cannot compel. So, this kind of property cannot be specifically decreed. You will get all these examples in section 10 and section 14 of your specific relief act. So, attachment and sale. So, first court will try to attach your property ki just okay, if this party judgment debtor becomes compelled because of this attachment, then it is okay. The moment court attaches your property, you say ki no, no, your lordship, I will pay this much amount just to get it released from the attachment. Second, if through attachment is not possible, then court will start the procedure of sale, sale through auction, because this is not so easy. Sale through auction, proper procedure, transparent procedure from beginning to end, because the court has to recover the good amount of that sale, good amount of money that out of that sale, because you cannot, if the property is of judgment debtor, the court cannot take it lightly. And apart from it also, there is one another thing very important. This is here like execution, here in the section itself. Execution, I mean the attachment attached property as per section 60, property which can be attached and which cannot be attached, court has to keep in mind simultaneously. You will get in this same thing, in the same section itself, like where the decrees for payment of execution by detention in prison shall not be ordered unless after giving opportunity of showing cause why he should not be committed to prison. In calculation of means of judgment debtor for the purpose, there shall be left out of account any property which after giving or for the time, or exempt, this one exempt from attachment in execution of the decree. It means what I am saying, attachment and sale. Here before attaching any property, court has to keep in mind section 60 of CPC also, कि this property cannot be attached and this property can be attached. I told you section, there are 9 property which can be attached, in which you will find book, accounts, all negotiable instruments, all those things are there. And the property which cannot be attached, like wearing apparels, cooking vessels, beddings, tools of artisans, the basic things, basic necessities, pension, gratuity, these kind of things cannot be attached, because this is related with your basic necessity. There is a 20 items in section 60 which cannot be attached, and 9 items which can be attached. Salary also, there is a salary portion also which can be attached and which cannot be attached. So, go through section 60, the property, both property you will find here. So, before attaching any property, court has to find out this one, okay, this property cannot be attached. Court will not take into account every property, even your necessary item cannot be attached by the court. And I am telling about sale. So, first this will come in attachment, and you have to, if you are talking about, if you are asking for attachment of property, then you have to find out, you have to be cautious whether this property can be attached or not. Court will not attach if the property is of necessary one, necessary of the judgment debtor, I mean to say. And then sale, I told you already, sale, how this sale will take place. Section rule 31 and rule 35 and 36. Apart from it also, we have rule 32. All 106 rules are very important, minutely read. If you want to start your practice, then you should read it properly, no need to ask from anybody else, bare act language, you will get the entire picture, complete picture of execution. 32 rules will tell you in case of restitution of conjugal right, in case of specific performance of contract, in case of corporation, if there is a decree against corporation, then there can be arrest and detention, there can be arrest and detention. So, what I am telling you, by sale without attachment of any property, second one is this one, by sale without attachment of any property means in case of perishable item, direct sale court will order direct sale without attachment, because if the court attaches his property and keep it in a store or in the custody of the court, then there would be no value of that property. Depending on the nature of the property, which property can be attached and which property cannot be attached, like in the form of storage. Otherwise, section 60 is there, don't misunderstood with this one. Section 60, property which can be attached and which cannot be attached is one, and apart from it, here I am telling you by sale without attachment of any property. If the item is of perishable one, then court will directly sell the property, not pass the order of attachment or adopt this mode of execution. First attachment, then sale. Third one is arrest and detention. Arrest and detention. Arrest and detention, this one, section 55 to 59, section, not rule, section 59, 55 to 59, you will get all provision of arrest and detention, because arrest and detention is really civil imprisonment, I am telling you, curtailing the liberty of anyone. Normally there is a amount also for this one, like first before passing an order of arrest and detention, in section 55 you will read the entire section, I have not mentioned here, section 55 you will study, you will read all those provisions, all those procedure what the court has to adopt before arresting someone. First opportunity, a notice would be given to the judgment debtor, an opportunity of showing cause ki why he should not be committed to prison, just in order to make him understand, like if he gives the money then it is okay, there will be no arrest, because there is a this order can be passed when the judgment debtor with the effect of obstructing or delaying the execution of the decree, then this order can be passed, is likely to abscond the local limits of the court. These all things you have to understand. I will let you know. Arrest and detention, see this one, decree for payment, in case of decree for payment of money up to 2000, there will be no 2000 amount. If the decree is for 2000 rupees, there will be no arrest. From 2000 to 5000, 2000 to 5000, 5000 there will be 6 week time, you will get in 55 to 56, 59 sections, you will get all these things. Above than 5000, above than 5000, then 3 month maximum, this is the imprisonment period. And moreover, this imprisonment period or this imprisonment, civil imprisonment is based on the subsistence allowance. Section 57 talks about it. What is subsistence allowance? The decree holder pay from his own pocket the subsistence allowance, and that is decided as per the rank and nationality and all those, the status of witness, the status of judgment debtor, rank of judgment debtor, subsistence allowance, survival allowance. Otherwise, you will not get the civil imprisonment, court will not pass the order of subsistence, this civil imprisonment. Another one thing, for specific performance, apart from this payment of money decree, specific performance of contract, restitution of conjugal right, section 9 of Hindu Marriage Act, restitution of conjugal right, if your spouse is not coming even after passing restitution of conjugal right decree, then also there can be a order of arrest and detention. In rule 32 of order 21, you will find this one, the answer of this question, specific performance of a contract and this one, restitution of conjugal right, or for injunctions, this the same thing is there. So this is arrest, subsistence allowance, and how women cannot be arrested in section 56, you will get the answer, all these one. This is the amount above than 5000, 3 months, 6 weeks, 2000 not allowed, no decree and no arrest and detention. How a judgment debtor may be released? On the amount mentioned in the warrant being paid. When there is a warrant, then if you pay the amount, then it is okay, there will be release, immediate release. Decree against him being otherwise fully satisfied, then again there will be no arrest of judgment debtor. On the request of the decree holder, if the judgment debt request of the decree holder, if the decree holder himself request, then also there will be no arrest. On the omission by the decree holder to pay the subsistence allowance, if the decree holder does not pay the subsistence allowance as per section 56 or as per whatever has been ordered by the court. Normally this is I think 90 rupees per day, you can check it out, earlier this was 70 rupees per day. So accordingly 90 into 30 days, it means minimum 1 month, then 2700 if the decree holder is not paying in advance to the court for the arrest and detention, civil imprisonment, then this is a failure to pay the subsistence allowance, then court will not pass this order of arrest and detention. Or on the ground of illness, if you are really, if there is a medical certificate, you are ailing from some sort of illness, then also there will be no arrest and detention. So, these things you can read from section 55 to 59, arrest and detention related provision, how arrest will take place, what procedure court will follow, what who is what is subsistence allowance, what is release, what is how court would get out of this one. This is attachment of property, section 60 already told you. Section 60 what is telling, attach property which cannot, like these are the examples, wearing apparels, these properties cannot be attached, these properties cannot be attached. This covers both property which can or cannot be attached. All saleable property is a part of attachment of property belonging to judgment debtor. So, court has to follow this one, which property is saleable one and which property is not saleable one, which property is exempted one, which property is not exempted one. Keep in mind before following or before adopting the mode of this attachment of property option. Sale of property, how this will take place, through auction proper, already time and place and all those procedures of auction will be followed by the one. Section 65 to 73, rule 64 to 95, you have to read one, then you will come to know the procedure of sale, how this procedure of sale will take place. I am just telling you in brief only, because unless and until you read, because this is a procedure only. If you do not read these sections I have already mentioned here and rules of order 21, then I have already given you the basic understanding of execution, but for that you have to club it with the reading of the Bare Act language, then you will come to know what would be the procedure of sale of property, how this sale will take place. Directly court cannot order, okay, sell it out. There is a proper procedure, and you can challenge also if you find any objection. If you find the judgment debtor finds no, there is auction is not as per rule, the sale is not as per rule, you can challenge it also. Judgment debtor can challenge it also. No doubt decree, because these are the mode of execution coming. But if you find there is no proper time and reasonable opportunity of hearing, there is no proper place of auction, there is no proper money which is being asked from the parties whosoever is participating in the auction, then you can challenge if there is, you find the procedure is not transparent. But you have to read for this all these rules related to these rules, court will move. This much, how purchaser, if auction goes in your favor, then purchaser has to deposit 25% of purchase money in advance when he can participate. Co-share has also right of preemption, all those things, these are different rules. The price of the property shall be paid at the time of the sale. On payment of price, the sale becomes absolute. In case of negotiable, the sale through broker will take place. Sale of all movable property in execution of decree should only be held at some place within the jurisdiction of the court, ordering such sale. This is the procedure relating to sale. How delivery will take place? Delivery, specific movable property, in case of specific movable property, by seizure and delivery, by detention, by attachment and sale, by attachment and detention both. So, all these rules 35, 31 I have told you. Appointment of receiver, order 40 deals with this one, appointment of receiver for the property, because receiver is a person who will preserve the property, who will manage. Instead of directly auctioning, court will, in rare situations, if court finds ki no, this is beneficial for both judgment debtor and decree holder, then court can appoint receiver also. Receiver is just like a liquidator, he is just like a guardian of the property. He will take into account, okay, he will preserve, manage, protect the property for the time being, unless the decree is satisfied otherwise. So, for that you have to read order 40 of CPC, then you can come to know about it, what is the role of receiver, when court can appoint receiver, and this is all about. So, finally, I will say this is a long last due process by which party do not get justice in time. That is the reason I have suggested you in beginning. Outside the court, if you get any opportunity, the decree holder, I am suggesting to decree holder in whose favor the decree has been passed, if they are getting decree satisfying outside the court through mutual consent or through any other way, then that is the best way, instead of adopting this procedure of execution. But if you find no other procedure, mutually this decree cannot be sorted out, satisfied, then execution is the process, court is always there. court is there to assist and court will follow this procedure of order 21 CPC execution procedure section 36 to 74 completely. So, otherwise just this is my suggestion ki this is a long due process, party do not get justice in time, this takes time, lengthy procedure, complicated procedure, specific delivery, arrest and detention, attachment and sale, appointment of receiver or any other mode, really these modes are very difficult one. This is all about order 21 execution, when execution means realizing the fruits of the decree. So, this is what I wanted to tell you here in this session. Thanks.